Welcome back to the Environmental Law Monitor. I'm your host, Daniel Pope. This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Group, and we're glad you're here with us today. In case you're listening to us on our website, I want to invite you to subscribe on Apple Podcasts, on Spotify, or on whatever your preferred podcast streaming service is. It was great to see many of you at our spring environmental law seminar in mid-May, and I believe I personally have recovered from the seminar and the many events that take place over May. I've got 2 little kids, and I don't think I realized when I was younger just how intense May can be for parents and adults with graduations, end-of-year parties, recitals, music performances, plays, and so forth. But we can all leave that aside for now because we've got an interesting program today covering litigation over the energy transition. And more specifically, over litigation regarding some of the challenges to new projects in the offshore wind space. Those projects are under development off the East Coast. And if you're aware of what's going on the offshore wind industry at all, you'll likely know that this is an area in which the energy sector is growing quite rapidly. We have development off the Atlantic coast that's already underway, but we're hearing more and more about upcoming leasing activity off the Pacific coast and the Gulf of Mexico. And it seems like there are just so many developments happening in this space. But don't take my word for it. I'm glad to welcome to the program, both for the first time, a couple of my colleagues here at Bracewell who are involved in the energy transition on a daily, if not hourly basis. First, I'm joined by Ty Johnson, a senior counsel in our Seattle office. He's got a broad background advising international energy clients across a wide array of regulatory issues. And then I'm also joined by Taylor Stuart, an associate in our Environment, Lands, and Resources Group who practices in very much the same area. Welcome to both of y'all.
Thanks. Great to be here.
Thank you, Daniel. Happy to be here.
So before we jump into talking about some of the legal challenges to the offshore wind projects that we're seeing sort of in New England and the Northeast, I think we need to take a 50,000 foot view of what offshore wind is, what's happening in offshore wind today as we speak, and then we'll talk about some of the statutory frameworks that are involved in reviewing and authorizing these projects. So Taylor, can you give us sort of a look at a snapshot of what's going on today in the offshore wind industry? That's a big question. It
is a big question. And maybe a better way to phrase it is what is not going on in offshore wind, because there's so much happening right now. Since Biden's inauguration, the federal government has really been pushing hard to really push offshore wind forward and kind of make up for some lost time during the Trump administration. So there's been a lot of leasing efforts on the part of the Bureau of Ocean Energy Management, which is the sub-agency within the Department of the Interior that's tasked with leasing parcels of the Outer Continental Shelf to developers for both oil and gas and renewable energy development. So in the past 2 years, BOEM has really been pushing forward on its East Coast leasing. So right now there are 25 active leases off the East Coast, and this includes the most recent New York Bight leases and the Carolina Long Bay leases that were recently auctioned off. But BOEM's also kind of pushing forward on other coasts as well. So as you mentioned, Daniel, they're planning lease auctions offshore California, both in Northern and Central California, and that will likely happen later this year. And then in the midst of all the leasing efforts, there are also dozens of projects that are in line for development. So 2 projects that have been approved off the coast of Massachusetts and New York, and then a number of projects that are currently being reviewed by BOEM and the other federal agencies for approval.
Taylor, that's really helpful. Can you give a little kind of overview on kind of what the prices for these leases go for? Or what's the trend line on these leases?
That's a good question, Ty. So they've been kind of ranging over the years. In the very early stages of offshore wind development, they were as low as something like $5 million. In 2016, they popped up to around $40 million. So they were really getting up there, and people were really shocked at those numbers. Over time, they went up to $100 million or so off the coast of Massachusetts. And then in this most recent New York Bight auction, they jumped up as high as we've seen them before. So anywhere from the 200 millions to the highest lease area went for $1.1 billion. And collectively, that New York Bight lease auction garnered $4.37 billion that went to the Treasury. So a huge amount of money that's going towards just these leases alone. And that's only the right to submit plans for the project development. That's not any right to actually develop the project or anything like that. It's just to submit plans to the federal government to eventually develop the project years later.
Yeah. So to sort of summarize that, there's a two-step process where you first obtain a lease, and then you have to develop a project, submit plans for that project, receive approvals for that project. So it seems like there are multiple federal decisions along the way before we get to, a new array of wind turbines in the water that we can take new pictures of, so we don't have to rely on the same picture of the Block Island wind lease, those same 5 turbines that we always see.
Well, they're all pretty similar looking, but you raise a good point here about the process. This is something it's worth spending a minute or two on, I think, because it's a bit of a unique process, and it's raised a lot of questions and has been the subject of litigation. So I thought I might just, in quick broad strokes, kind of put a little bit more meat on the bones on what the process looks like. So you might ask, how are areas for offshore wind leasing identified? Well, BOEM has a process for all that. And, one method is a developer may identify a juicy piece of real estate off the coast of whatever state and submit a bid for a request for a lease for that piece of offshore real estate. BOEM would then kind of try to figure out whether there's competition for that lease. It'll issue some notices saying who else out there might be interested in that. BOEM is trying to get kind of top dollar for this very limited and unique pieces of offshore real estate for renewable energy development. If there is interest, BOEM will kind of go down this competitive leasing process, but it will also kind of bend over backwards to seek input from all sorts of stakeholders. For many states, it's set up what they call intergovernmental task forces, where they have the meetings with various state agencies that have a real interest in identifying which areas off their coast might be appropriate for offshore wind leasing. There are also a number of comment opportunities for the public, for the fishing industry, for other stakeholders to weigh in on the appropriateness of an offshore wind project cited where the lease has been proposed. So that's kind of the area identification process, and BOEM will have a decision-making process will ultimately lead to a decision to issue a lease off of a given state. It'll then kind of, assuming it's a competitive process, it will hold an auction for that lease area. And there's a process around getting the format of that auction just right and figuring out who's qualified, et cetera. And then once the winner of the auction actually wins the lease and executes the lease agreement with the government, then there's a site assessment period. And to Taylor's point earlier, I think it's worth highlighting, and this has been litigated, that holding a lease does not grant the leaseholder a certain right to develop an offshore wind project. It is the right to submit plans to develop an offshore wind project, an exclusive right as against all others. So this is very important. It does not authorize an offshore wind project to be constructed. The plans that can be submitted are a site assessment plan. So you've got this large lease area. It's got uncertain bottom conditions, seafloor conditions, geotechnical and geophysical conditions, as they're called. And there's a lot of surveys that have to be performed. You've got to figure out where it's appropriate to site these very large wind turbine monopiles or other types of foundations, where to put the cables, for example. You can also deploy buoys and towers to figure out the wind resource of the area. I mean, how much wind, how consistent is it really in that area? And then once you've finished that process, you typically would submit a construction and operations plan, or COP, as they're called, which is essentially your permit application to construct an offshore wind project. Typically, that COP is the pivot point where the agency, BOEM, and all the cooperating entities are really starting to look at the impacts of constructing an offshore wind project. And there is, of course, yet another NEPA process surrounding the review of that COP. So I hope that's helpful. But those are it's very important to understand the steps in the process, because a lot of the litigation is tied to those various steps and what they mean.
Well, yeah, let's jump in a little bit more deeply there then, Ty. And you sort of suggested that there may have already been some offshore wind cases that were litigated to a resolution or a court order. What precedent is out there for offshore wind? Because I think when we were talking earlier, I had sort of assumed that, this is a new and sort of exploding area in the energy sector, and that the cases we were seeing today were sort of the first cut, but you suggested there's more precedent out there. So what is out there in terms of offshore wind litigation history?
You're right. Things are exploding now, and Taylor has all the insights on the current crop of litigation. But quickly, there are kind of two pieces of precedent here. One surrounds the ill-fated Cape Wind project, which is kind of proposed just off the coast of Cape Cod in the Sound between Martha's Vineyard and Nantucket. And this project garnered a lot of media attention, and ultimately, of course, was never constructed. But it was mired in litigation. Various suits filed at the district court, and ultimately at the appeal to the D.C. Circuit. The litigation there involved a host of violations of NEPA, the Outer Continental Shelf Lands Act, the organic statute, giving BOEM the authorization to issue these leases.
We can call that OXLA. I have a tough time with that one too.
Yeah. OXLA is the term of art. The National Historic Preservation Act, Migratory Bird Treaty Act, Endangered Species Act, Marine Transportation Act. So the kind of the usual suspect of statutes. Various plaintiffs allege that the relevant agencies, namely BOEM and its predecessor, and the Coast Guard and Fish and Wildlife Service, had all violated. The ultimate outcome here was that the D.C. Circuit ultimately criticized how BOEM complied with NEPA, basically deferring on geophysical and geotechnical surveys to the point where it was kind of not sufficiently informed for the purposes of NEPA to render a decision on approving the project. There was also some criticisms about the Fish and Wildlife Service's compliance with the Endangered Species Act and failure to address some of the plaintiffs' claims about the lack of best available scientific data. So that project was the D.C. Circuit sent that NEPA document back for supplementation. And of course, that project ultimately never went anywhere. But the issues were kind of your more or less bread and butter kind of NEPA, Endangered Species Act type of litigation claims. The other more relevant and more focused on the offshore project and its current leasing paradigm. And it's important to note that in 2009, BOEM revised its regulations that set up the entire permitting regime that I kind of surveyed a few moments ago. And so the Cape Wind litigation occurred kind of before that whole leasing paradigm was established. But now with the new regulatory paradigm, the Equinor's lease off the coast of Long Island for the Empire project, the various commercial fishing interests sued to try to challenge the issuance of that lease, and they filed suit under OXLA. And they were fundamentally concerned about the location of the lease. Did BOEM really cite it in an appropriate place? Did BOEM consider the impacts to the fishing industry? But ultimately, the issue that was appealed and resolved favorably for BOEM was whether or not, at the time of issuing a lease, whether BOEM had to conduct a NEPA analysis for the entire offshore wind project. And as you recall, right, issuing a lease just grants the lessee the exclusive right to submit plans. And the lease is very, very explicit about what it does and does not authorize, and being very clear that it did not authorize any construction of anything. The DC Circuit. Maybe to paraphrase what a lease is, it's, to quote a great American film, so you're saying there's a chance. There's a chance. Yeah, there's a chance. And, interesting. And the reason I asked Taylor about the prices for these leases, well, that was kind of a material fact in the DC Circuit litigation, right? Equinor paid roughly $42 million for this offshore wind lease, and the commercial fishing industry was kind of using that to say, no reasonable developer would pay such a sum for the chance to develop a project. Well, unfortunately, that's exactly what the lease says. It's just a chance. But I think as the lease prices escalate, the optics of paying $1.1 billion for a chance becomes a little bit more tenuous, right? But ultimately, the lease terms remain unchanged, and BOEM's not going to issue a lease with any kind of right to construct and operate an offshore wind project. So those are the two pieces of precedent in history. So not a whole lot, and not a whole lot challenging BOEM's regulatory regime either. So we're kind of in a bit of a brave new world in this nascent industry.
Yeah, so Taylor, let's go to you. What can you tell us about the challenges that are pending in court today? I know that Ty sort of mentioned that we've seen some interest from commercial fisheries. I'm sure that there are a number of environmental NGOs that are wanting to ensure that the regulatory review process for these leases and for the COPs are adequately taking into account a variety of environmental impacts, whether to the environment itself or to species and so forth. So where are we today with that?
Sure. So there are about half a dozen cases that are pending today, and most of them are from, fishing industry, resident groups, environmental NGOs, or in one case, we have an onshore solar developer. So that's a little bit of an outlier, but those are the typical groups that we've seen in the past and that we're seeing now. And we're seeing a few cases that are challenging the project at kind of different stages. So as Ty mentioned, the Fisheries Survival Fund case in the DC Circuit was challenging the lease issuance, but right now we're seeing cases that are challenging the first COP approvals that we've seen from BOEM. So for the two currently approved projects, and then we're also seeing a challenge to the area identification process and the New York Bight. So for the cases that are challenging the actual project, so there are two projects that have been approved by BOEM and have received their kind of green light to begin construction. So the first is Vineyard Wind Project off the coast of Massachusetts, and the South Fork Wind Project off the coast of New York. And in these, we're seeing complaints both in Massachusetts District Court and the DC District Court. So a couple different forums there, and there have been, quite a few arguments about transferring, consolidating, because they're all very much overlapping with one another. But we're kind of seeing some trends in the claims already. So as Ty mentioned, there's kind of a typical swath of claims that you'll see. The claims under the Outer Continental Shelf Lands Act or OXLA, claims under NEPA, under the Species Protection Statute. So Endangered Species Act, Magnuson-Stevens, which is a requirement that NIMS consult with, the National Marine Fisheries Service consult with the project and other agencies about impacts on essential fish habitat. So those statutes are definitely showing up in a lot of these complaints. And even though these are kind of in their early stages, we're seeing some trends come up in some of these cases against the actual project approvals. So in the cases that are in the District Court of Massachusetts, it's Alco v. Holland and ACRATS v. DOI, which is the Nantucket Residents Against Turbines, I believe, if I have their acronym right. But one is an onshore solar developer that's challenging the Vineyard Wind Project and is now seeking actually to join in the South Fork Wind Project, but that's for a whole other podcast.
Taylor, your question, why would an onshore solar developer challenge offshore wind project? What's the logic behind that?
That's a great question, and it's logic that the court is grappling with right now. So the Alco companies are arguing, and their CEO, who has also drafted their complaint for them, are arguing that the offshore wind development, that the federal agencies have not adequately considered onshore solar as an alternative to offshore wind development, and that arguably offshore wind threatens the success of onshore solar, and they're making those arguments in quite a few kind of convoluted ways that are wrapped up in some of these statutes that I mentioned. But I think that case will, particularly of all of the cases, will have quite an issue with standing. So the government is, of course, arguing that those companies and that their CEO do not have standing to sue on the basis that offshore wind threatens their industry, and that's not, a cognizable harm that they can sue on. So that's definitely a big issue in that case. And like I said, that one is a little bit of an outlier.
Is that sort of like an exploded NEPA claim that the offshore wind industry just has to consider a massive range of renewable alternative a massive range of renewable projects as alternatives to their proposed project? Or is this just totally throwing something crazy at the wall?
I think it's a little bit of both. So I think that there is some kind of cognizable argument there that under NEPA, an alternative that should have been considered by BOEM and the other federal agencies is onshore solar, but also under NEPA, you have to consider the purpose and need of the project. So in this case, the purpose and need and the intention of the developer is to develop an offshore wind project, not to develop an onshore wind project. So that argument probably won't stick, but I think the developer is trying to make the point that onshore solar, in its mind, arguably could be less impactful than offshore wind, and therefore it should have been considered as an alternative to these projects. But those issues are kind of wholly separate and apart from BOEM's responsibilities to lease offshore parcels for renewable energy development. That is the agency's kind of guideline. So what happens onshore is really kind of not of the Bureau of Ocean Energy Management's concern.
Taylor, I know these cases are pretty interesting. The Cape Wind cases that I mentioned earlier, and so much of the media attention of this project was all about viewshed, views. We heard a lot of about prominent public figures funding a lot of the opposition to the project due to the presence of their family compounds on the Cape. Are we seeing that issue as being kind of front and center in this current round of litigation, or are we kind of moving away from views directly and on to kind of other bread and butter environmental issues?
That's a good question. I think that the viewshed issue is still very much at the heart of this, but you won't see it as much on the face of some of these pleadings. So what a lot of these resident groups are understandably concerned about are viewshed impacts and the impacts on real estate values and on tourism, but that really isn't coming into play as much in the pleadings. So the pleadings are more focused on how is this going to have a concrete impact on endangered species? How are these projects going to impact the North Atlantic right whale? How have the agencies gone about analyzing the impacts of these projects, and have they done that in a proper way? And I think what many of the plaintiffs groups are concerned about is viewshed and impacts on viewshed, but I think some stronger arguments come from some of these other arguments related to species impacts and related to whether the proper procedure was followed. So that seems to be more of the focus of the pleadings.
So it seems like we've got quite a few cases to track, and with the upcoming rounds of leasing activity, not to mention the fact, I think, Taylor, you said something like 20 or 25 leases have been issued. So we're going to see new project proposals from those leaseholders over the next few years. We're going to have a lot of opportunities to see the offshore wind litigation industry become a reality as well. I'm curious to hear from both of you what you think the significance of some of these challenges are for the offshore wind industry itself. Is this sort of garden variety administrative litigation, or is there something else going on that the industry is really going to have to grapple with?
Maybe I'll take a go at that, and then Taylor, you can bail me out when needed here. But Dan, it's a good question. I think it's some of both. Some of the litigation is focused on trying to invalidate BOEM's leasing process and its kind of staged development process for offshore wind projects. Particularly, it's attacking how it identifies lease areas. And I feel like one of the kind of fundamental concerns that we hear from opposition to offshore wind projects is that they don't feel like they got an adequate say in where an offshore wind project is located. So one project or one piece of litigation, the Save Long Beach Island case, which is a group based in New Jersey, challenging. It looks to challenge fundamentally BOEM's offshore wind leasing program, that regulatory paradigm that was established in 2009. So if successful, there could be ramifications to the agency in the entirety of its leasing process. Many of those same issues were successfully resolved in BOEM's favor in the regarding Equinor's lease for the Empire Wind Project, the DC Circuit case that I mentioned. The decision was issued just last year. So there's some helpful precedent in defending the leasing program there. But nonetheless, I think we'll continue to see challenges to that leasing process. And then the other piece of it, too, is challenges to agency approvals and their associated NEPA analysis. That I think is more in the bread and butter category of things we see in other types of infrastructure development. But nonetheless, they'll have this kind of unique offshore wind twist where everything will be kind of, obviously couched and framed as offshore wind related issues. I think we'll see a lot of species related challenges.
Yeah, I'd agree with that kind of division, Ty, that the cases that are more focused on BOEM's process and the regulatory program are cases that are kind of separate and apart from these kind of traditional bread and butter project challenges, that they really do kind of threaten to upend, a portion of BOEM's regulatory program that's been very much in flux in terms of the guidance that BOEM has issued and the policy that it's implemented over the past few years. And we've heard now that BOEM is considering a regulatory change itself and amending its regulations and making changes to reflect some, more modern changes of the offshore wind industry that are happening now. So we know that that's coming. And I think that something to consider with the project approval cases is that, it is really important to engage with potential plaintiffs groups as early as possible, So as much, outreach as possible and, potential mitigation early on in the process will really help developers avoid some of this really costly and time-consuming litigation on the back end. So it's important for us to look to those cases now to see kind of how they pan out and how can they guide us going forward. And not only, outreach to plaintiffs, but also considering how do you design the project, how do you ensure that the administrative record is as robust as it can be. All these things can be looked to for guidance for developers now and how things should be done going forward.
I think that's a point that we have hammered over the past several years in our practice group, Taylor, with so many statutes in play, with so many federal reviews in play, with so many opportunities for an agency to come to and make a final agency decision on a variety of issues. I think it's absolutely essential that project developers of all kind, whether they are offshore wind companies or engaged in some other sector, that they pay attention to and participate in the federal review process to the maximum extent possible. Because really that's sort of about protecting your own investment and protecting your business model. And it's not just the alphabet soup of administrative law. It really is about getting to that good result and ensuring that a record is defensible, because I think, you mentioned we have commercial fisheries involved, conservationists, people concerned about their view sheds. There are a lot of different possible approaches to challenging one of these projects. And you really want to know what's in that record, because you don't know who's going to be coming into court. The only thing that you control is the record that you go to court with.
And Dana, that's an excellent point, but I might go a little bit further in terms of stakeholder involvement and outreach. There are, of course, federal processes, right, associated with many different agencies and their reviews. But I think there's also a lot of benefit from a project applicant, a developer, being proactive and engaging with the communities and the affected stakeholders, so that there's kind of that early and frequent touch points, information updates, solicitation of input on the project. It'll also certainly help, with the political process, political support for the projects and getting those, especially those local permits that are ultimately necessary for a project.
Well, it's something that we'll be continuing to monitor as these new complaints are filed, as new major pleadings or motions are submitted to the court for the court's resolution. Ty, Taylor, any concluding thoughts on our conversation? What are you thinking about as you look out over the next year for what's going on in the offshore wind space?
Just trying to, keep track of everything. As we said, there's a lot going on the leasing front. There's a lot going on the litigation front. So it's a lot for developers and for their lawyers to keep track of. So it's more just kind of keeping a touch point on everything. And I'll say that, we really want to look out for these first approvals. We haven't seen injunctive relief being granted for them yet. We haven't seen an injunction to Vineyard or South Forks construction, but we really want to watch out for, any enjoyment of construction or any stop on construction that could add a delay there. That's something that developers really want to keep apprised of and make sure we're aware of any delays that result from some of these cases. So we'll keep a close eye on that and look forward to seeing, what BOEM does for the rest of the year in terms of its leasing efforts. It's looking like it's going to be a really, really busy. It has been a really busy 2022 for them, but the end of the year is going to be even busier for the agency. So we'll keep a close eye on that as well.
Yeah, I think you said it well there, Taylor. There's a lot to keep track of. I think it'd be prudent for developers to keep a close eye on these different pieces of litigation to understand what the consequences might mean for their own project and how they structure their permitting strategy and how they interact with the agency to try and accommodate the potential arguments plaintiffs might raise. So. Yeah, it'll be I think pretty impactful for the industry as these cases mature. We finally start getting some decisions on the merits, but otherwise it's going to be a busy year with many more opportunities for additional cases. So we'll be on top of all that.
I think it'll also be interesting to see how this administration navigates. I think one of the tensions with offshore wind and other kinds of renewable development, which is that at the same time, this administration is trying to foster or nurture the energy transition away from more carbon-intensive forms of energy to offshore wind or solar or a variety of other kinds of projects. The administration is also, in their view, rehabilitating a variety of environmental reviews and procedures that it believes the previous administration limited. And those potentially provide more opportunities for project opponents to challenge some of these offshore wind projects. And again, tons of other projects. That's not an observation limited to the offshore wind industry. That's something that we'll be reviewing and paying attention to. If you're curious about that subject, I'd encourage you to check out one of our previous episodes on the NEPA rulemaking process. It still has a lot of good content there if that's something that you're curious about. But that's it for this episode of the Environmental Law Monitor. Thank you, Ty. Thank you, Taylor. And thank you, Julia, Dorn, and Emily for all you do to support the podcast. Do reach out. If you have any questions about this podcast, you can reach me at daniel.pope@bracewell.com, and I can put you in touch with someone who is way up to speed on offshore wind, litigation, project development, and otherwise. Stay tuned for our upcoming episodes, and we will talk to you soon.